Okay, people come in.
Welcome everyone. We see that a lot of people are coming in. We will get started shortly, so we're just waiting for a few more people to come in, and we'll start. Just for your information, for those who've just joined us, we're just waiting for a few minutes. And this event is being recorded, and it's also currently live streamed on YouTube. And we will be starting shortly. Okay, good afternoon, everyone. I think we will start our webinar. I'd like to extend all of you who are just joining us or who have just joined us in the past few minutes a really warm welcome. This is our webinar entitled Human Rights of Migrants, COVID-19 and the European Convention on Human Rights and the European Court of Human Rights. This webinar is a collective effort. It has been co-organized by the Hertie School, Center for Fundamental Rights, University of Leeds, University of Liverpool, and the Strasbourg Observers. And some of you may have joined us earlier. This is the fourth in a series of webinars that have been co-organized by a fantastic consortium of human rights scholars in the UK and together with the Strasbourg Observers. My name is Başak Çalı. I'm a professor of international law at the Hertie School, and I direct the Center for Fundamental Rights. I'm going to be co-chairing this webinar today, and my co-chair is Professor Constantin Zichteru from the University of Liverpool. We have two parts of the webinar. We will first have our panelists discuss and give their papers. And in the second part, you will have a chance to ask questions. You can ask questions by using the chat function, or you can also raise your hands on Zoom, which is a little feature that you can use, and you may take the floor and ask your question. So let me still continue to warmly welcome everyone who are still joining us. If you also would like to discuss the issues live that we will be discussing all together here via Twitter, you can also use the hashtag that we have for the event that you see just in front of you. And this is HR versus COVID as a hashtag. So as you all know, the COVID-19 pandemic introduced immobility and social distancing to our everyday lives. Yet those of these measures played out very differently in migration control, and they also affected human rights of migrants and refugees in very different ways across Europe and also elsewhere. Some states have closed their borders, ports and airports altogether. Other states have halted deportations and detention, yet some other states continue to deport unwanted migrants. States extended pandemic unemployment benefit to regular and irregular migrant workers. And also in somewhat perhaps a contrast, we've also seen a very significant import of seasonal workers in considerable numbers across Europe. So we have seen both mobility and immobility across these varied responses. Today, I'm joined by a stellar panel to discuss the implications of these varied responses to the pandemic for the human rights of migrants and refugees within and outside the borders of Europe. In this context, we will also have an opportunity to discuss some recently delivered migration and asylum-related judgments from the European Court of Human Rights, perhaps as well as the Court of Justice of the European Union. So these cases are not necessarily COVID-related cases, but they were delivered during COVID. And of course, the context in which they're delivered, we find also very significant. So each speaker will have 12 minutes. And as I said, after the interventions, we will have a Q&A session where you will be able to interact with our panelists. So let me introduce our first panelist, and I will introduce our panelists in the order when they take the floor to speak. Our first panelist, thank you for joining us, Violeta, is Dr. Violeta Moreno-Lax. Dr. Violeta Moreno-Lax is reader in law at Queen Mary University of London, where she founded the immigration law program in 2014. She's the coordinator of SarabMed project, which documents and analyzes human rights violations resulting from interdiction operations at sea. One such incident has formed the basis of the SS and others versus Italy case, pending currently at the European Court of Human Rights, where Violeta acts as the lead counsel for the applicants, denouncing refoulement by proxy practices conducted by Italy through the Libyan Coast Guard. In her intervention today, she will focus on some of these varied responses that we want to discuss, with a particular focus on Italy and Malta. Thank you again, Violeta. The floor is yours.
Thank you. Thank you very much, Bashak, and thank you very much to the organizers. I have a PowerPoint. So I'm wondering if we're ready to display the slides. Right. So I'm going to be speaking about the impact of COVID in entrenching death as a means of border control. If we can show the next slide. Right, so the overview of what I'm going to be doing in the next 12 minutes, it's here. I'm going to be looking at the impact of COVID, as I was saying, in the management of maritime migration and how death has arising as a particularly controversial tool of migration and border control that the pandemic has sort of justified, legitimized, or at least normalized. I'd like then to problematize this approach and say that death, even by omission, constitutes a violation of international law. And it's particularly problematic from the perspective of human rights law, but not only. So I'm going to be showing you how this is problematic also from the law of the sea perspective, and how international law would help us establish responsibility, legal accountability, as it were, and then a couple of concluding thoughts and lessons for the ECHR framework, which has not yet pronounced itself on this very practice. So next slide, please. As I was saying, COVID and the outbreak and the emergency and the necessity to respond to the crisis that has come with it has helped structuralize exceptional responses by EU Mediterranean countries, including particularly Italy and Malta. My colleague Minos Mouzarakis is going to be speaking about the Greek experience. I'm not going to be touching upon the Eastern Mediterranean, but similar practices have been adopted by all the coastal EU member states. And these range from adopting secret deals with the Libyan Coast Guard, for example, or renewing older ones, like the Memorandum of Understanding that Italy concluded in 2017 with the Government of National Accord, to stem migratory flows along the Mediterranean route. There's been transfer of funds to Libya in more overt and covert ways, again, by Malta, Italy, and also the EU at large, to ask the country to contain exits and impede the arrival of unwanted maritime flows. NGOs practicing rescue and performing action of assistance and recovery of migrants at sea has been criminalized, particularly again in Malta and Italy. These two countries have been asking private shipping vessels to conduct pullbacks by proxy on their behalf and engage in the wider policy that Italy and Malta are practicing, using the Libyan Coast Guard as a medium to refuel maritime migrants. And the three most recent measures that we see Malta and Italy adopting as a direct result of the COVID outbreak are port closures and the declaration of on ports as being unsafe for disembarkation of migrants that we saw Italy and Malta adopting, as I was saying, in late March, the beginning of April. There's been also a new practice of detaining migrants in floating centers moored right outside the rim of territorial waters. This is a practice that has been adopted by Malta. And the most problematic, and the one with which I'd like to engage a bit further, the abandonment at sea or letting to die approach adopted by the two countries. So the next slide, please. This abandonment by sea and letting to die approach that has been adopted by Italy and Malta are framed as what I've called a death-based containment model, which consists in the systematic entrenchment of the risk of migrant deaths as part of an effective control of entry. And I'm using the words here of the UN rapporteur on extrajudicial killings, who was in 2018 devoting a whole thematic report to the situation of migrants' deaths as a result of border controls. So I think this has acquired a particular topicality that we see exacerbated by the action of COVID-19. There is a tactical disengagement from search and rescue at sea that produces death by omission as a means of containment of unwanted refugee and migrant flows across the Mediterranean. So if we could get to the next slide. I have here a summary of the chronology, because obviously I'm saying COVID exacerbates practices that have been adopted earlier and that have a broader genealogy. So if we go as far back as 2014, we would see that the Mare Nostrum operation, which Italy had adopted in response to the mass drownings of Lampedusa in 2013, was cancelled because it was perceived as producing a pull factor and attracting unwanted arrivals. There was then a further response from the European Union in the downscaling of the Frontex Themis operation, which was a border surveillance operation, and because its involvement in search and rescue at sea was perceived again as creating a pull factor, we saw a downscaling of the remits of the cover of the operation. In 2019, and this is the most astonishing development, the EUNAVFOR Med Operation Sophia, again a European Union naval force mission, surprised stakeholders, announcing the withdrawal of assets. So the withdrawal of ships, the withdrawal of naval assets from a naval operation. I think it's a very astonishing development indeed. And instead launched a drone-based surveillance operation to deliver intelligence information to Libya so that the Libyans could then come and retrieve migrants, interdict them, and return them to the port of departure. COVID, as I said, inscribes itself in this genealogy, in this chronology. Port closures and abandonment at sea, as adopted by Italy and Malta, are sort of the culmination of this disengagement, strategic disengagement from SAR that we've seen the coastal Mediterranean states adopting to preclude unwanted migratory flows towards Europe. If we can go to the next slide. I have some of the statistics. Obviously, statistics take a while to catch up. So the numbers that I have from IOM stop in 2018. The ones from UNHCR stop at 2019. So I don't have numbers for 2020, where we could see particularly the impact of COVID, but you can see the trend. So there's been a sharp decrease in arrivals that this tactical disengagement from search and rescue at sea has led to. And in parallel, a sharp increase in the death rate. So we see that for every 38 arrivals back in 2017, only one person would have died. And this proportion has increased dramatically in 2019, only 2 years later, so that now for every 3 attempts, one person is at risk of losing their lives, as calculated, as I said, by UNHCR. So if we move to the next slide. All of this is problematic for international law from the perspective not only of international human rights law and the ECHR, but from a more general angle. So if you would take customary international law as a basic premise, we would see that there is a basic duty to protect human life at sea, which is part and parcel of what has been called elementary considerations of humanity. This has had a translation in the law of the sea, and particularly in the three main instruments that articulate the duty to provide assistance to search and rescue at sea, in the UN Convention on the Law of the Sea, the Search and Rescue Convention, and the Safety of Life at Sea, or SOLAS Convention. In these three instruments, this sort of broader duty to protect human life as part of the elementary considerations of humanity is put into detail, and it decouples in several components, so that there is a duty to require ship masters flying the state's flag to render assistance, and there is a duty on the part of the flag state itself to establish search and rescue services for both not only searching but also rescuing anyone who would be in danger of being lost at sea. There is also a duty to designate search and rescue regions where primary responsibility is assumed by the declaring country to ensure that rescue is coordinated and assistance delivered appropriately. They also need to determine and put forward a mechanism, a service that is coordinated by a Maritime Rescue Coordination Center, which is responsible of the assistance action. And there is a duty to ensure that the necessary arrangements are in place for coast watching and, as I said, proactive rescue. So there needs to be a concrete engagement with the effort of assisting people in distress and retrieving and preserving their lives so that they are not lost at sea. And the scope in personal terms of this duty is universal. It doesn't matter whether we are talking about the citizens of particular countries, forced migrants, or maritime migrants of any sorts, regardless of their condition and regardless of any considerations that one could have in mind. So next slide, please. The Human Rights Committee, in a general comment that is an updated version of their general comment on the right to life issued in 2018, makes very clear that omissions, also in the context of the sea, the maritime migration situation, is relevant, and that the right to life attaches a number of positive obligations, so that there is an expectation that countries are going to be adopting positive action to avoid that foreseeable death materializes in the end. So the right to life, according to this general comment, includes a number of different components, but it makes very clear that not only acts but also omissions could lead to the establishment of responsibility, that arbitrary deprivation of life, whether it involves an intentional or otherwise foreseeable and preventable life-threatening situation, needs to be foreclosed before it materializes, and that states must refrain from any sort of conduct that would result in this arbitrary deprivation of life, ensuring that they exercise due diligence. And this positive obligation, as I was saying, includes the duty to take adequate measures of protection, especially towards persons in situations of vulnerability, including asylum seekers, and entails a duty to organize all state organs in a way that is consistent with the need to protect human life. So you have the references on the slides to the relevant paragraphs. This argumentation, or at least this line of narrative adopted by the Human Rights Committee here, has been incorporated in the argumentation in favor of the plaintiffs in the application of S and others versus Italy, which is currently pending before the ECHR. Next slide, please. So the problem, one would say, is how to determine responsibility and avoid that these entrenchments of abandonment at sea policies gets normalized. So the law of the sea, I think, is particularly clear in adopting a functional approach to jurisdiction that allows us to determine that this kind of action, like port closures, detention at sea, and abandonment at sea, as well as negation of rescue, constitutes a violation of the relevant provisions. The trigger to the establishment of responsibility for both flag and coastal states in this particular context is, according to the SOLAS Convention and the STAR Conventions, the receipt of a signal from any source that persons are in distress and in need of assistance. And from any source, I think, would include knowledge that countries would derive from satellite imagery, communication with the Libyan Coast Guard, satellite phone communications by the people in distress themselves, or, for example, requests for assistance coming from the Alarm Forum or other NGOs that act as relay between the migrants found in distress and the relevant rescue coordination center. Next slide. So I think there is some learning that can be done from this configuration of jurisdiction, this understanding that jurisdiction tracks the functions that the state needs to discharge. So that's what the functional approach in my mind stands for. And that's the use that we've made of the terminology in the SS case. And I think this is reinforced by the understanding of the Human Rights Committee in the general comment that we've already mentioned, whereby they understand that people fall within the jurisdiction of the state for human rights responsibility purposes whenever persons fall within the powers of a state that is exercising effective control and authority in situations where the enjoyment of the right to life is at stake. And this includes people whose right to life is impacted by military and other activities. So one could say border control or migration control activities in a direct and reasonably foreseeable manner. And the Human Rights Committee makes clear that this includes situations of distress at sea. So individuals who would find themselves in need of assistance so that their lives are spared would come within the remit of this pronouncement and this understanding of the general comment by the Human Rights Committee, embracing a functional approach. So coming to the conclusions in my next and final slide, I think there is a number of lessons for the ECHR framework that I think constitute the main takeaways from this brief presentation. And just to wrap up, so the COVID-19 emergency rhetoric has been adopted as justification to embed the risk of death as a means of migration control. This is particularly problematic. The ensuing death-based containment model entails a policy of disengagement from search and rescue that leads to an increased probability of death by omission, which constitutes a violation of the law of the sea and human rights obligations of coastal states. This entails international responsibility if we embrace, as the Human Rights Committee does in its general comment on the right to life, a functional approach to jurisdiction, so that the strategic non-use of sovereign powers that we see Italy and Malta doing as a result, or in, with the excuse of the COVID emergency, in extraterritorial scenarios, including at sea, does not escape legal accountability. So that in situations like the one denounced in the SS case, Italy and any other country adopting similar practices should be considered responsible under the ECHR framework. If you're interested in knowing a bit more, there are a chapter and an article that I've written about this, one forthcoming, but one already out, which would provide further context and the whole argumentation if you're interested. Next slide, and with this I close. Thank you very much for your attention.
Thank you very much, Violetta. I think this is very significant. That you're saying that this problem is an ongoing and a continuing problem of deaths at sea, but you're kind of exposed the view that people are trying to not justify, but maybe normalize, further normalize these practices. Is I think what your paper has very clearly underlined. Let's move on to our second panelist. Our second panelist today is Minos Mouzarakis. Minos is a legal officer at the Refugee Support Aegean, an organization providing legal support to refugees and defending human rights in Greece. He has previously worked at the European Council on Refugees and Exiles with a focus on the common European asylum system. In his presentation, he is going to focus on the responses in Greece in the aftermath or the duration of the COVID-19 pandemic with a specific focus, well, a number of dimensions, including non-refoulement, detention practices, and some of the engagements that human rights lawyers had through interim measures with the European Court of Human Rights in this context. Thank you for joining us, Minos. The floor is yours.
Thanks very much, Bashak, and thanks again to the organizers for putting together today's discussion. It's extremely topical, and also, of course, useful to compare the different regional, the different national perspectives when it comes to how states have made use of the pandemic to adapt or to reinforce some of the sort of established policy goals when it comes to migration and refugee protection. So as mentioned, I'll try to cover the latest developments in Greece relating to detention and non-refoulement. As a preliminary remark, what would be necessary would be to consider the legal and political context that was unfolding in the run-up to the outbreak of the pandemic, because that sort of set the scene for some of the practices and policies that we saw being rolled out by the authorities. So as you've all followed, at the very beginning of March 2020, Greece took a number of severe measures when it comes to its asylum system as a response to what it's described as an asymmetrical threat coming from Turkey through large-scale arrivals of refugees and migrants at the land border. So in addition to border closures, this was also coupled with a 1-month suspension of access to the asylum procedure, a very radical and ubiquitously unlawful move when it comes to the Refugee Convention that was unfortunately not only lauded domestically by different political parties as a necessary solution, but also received a bit of a tepid response from the European Commission and other institutions. The reaction was not strong enough to point to the violations that Greece was engaging. So in a way, this context enabled Greece to put forward and to start implementing specific policy objectives, including a zero arrivals narrative that has more or less continued to present. And of course, the COVID-19 outbreak came a couple of weeks after, but in a number of respects, it could be seen as an enabler in the way the authorities have treated it to continue those policies. And now, focusing on deprivation of liberty on the one hand and on non-refoulement on the other, there's a number of different elements that reinforce the belief that the current context has been used by Greece in a way that flouts fundamental legal obligations, and the response from redress mechanisms has been a matter of concern in relation to making sure that some of these violations can be stopped or at least sanctioned. If we look at the question of detention first, what followed since the 1-month suspension of access to the asylum procedure was a policy of blanket detention of new arrivals. So whether people were arriving through the land border of Evros or through the Eastern Aegean Islands, the immediate action taken by the authorities was detention plus deportation decision without any individualized assessment, including for vulnerable people that are expressly protected from deportation in specific cases, for example, women in advanced pregnancy. And of course, without any consideration of the asylum legal framework, even where people made an asylum application as per EU law, where they expressed the intention to seek international protection in Greece. Now, this means, of course, that people were held en masse in detention, very often in unofficial facilities. So what unfolded in March was a situation whereby people were held near ports on the Aegean Islands, in army vessels en route to detention facilities on the mainland, and in 2 dedicated detention centers that Greece set up specifically for that purpose, for the implementation of that March 2020 decision. No known health and prevention measures have been taken to make sure that people held in those conditions would be protected against COVID-19. Conditions have been documented by a wide array of reports as wholly inappropriate and arguably reaching the level of inhuman and degrading treatment in and along that way of transfer from the islands to the mainland. So also at sea, also in those new detention centers. And from the point of view of domestic courts and redress mechanisms and remedies against detention, the response has been largely deferential to the government. So specifically when it comes to the national remedy for challenging administrative detention, the so-called objections procedure before the Greek administrative courts, that has been criticized on several occasions by Strasbourg as an ineffective remedy. The position taken, at least by the Athens court, in several cases of people detained in one of those detention facilities, the so-called Malakasa camp north of Athens, was that Greece was justified in adopting those measures and in suspending access to asylum given the severity of the threats to its national security, that the arguments made relating to COVID-19 prevention in those facilities were not substantiated, and that detention was clearly lawful, even though people had sought international protection and the claims had never been registered. Where Strasbourg came in was a particular case concerning 2 unaccompanied children detained in that facility, again, based on automatic detention policy implemented by Greece during that period, where RSA lawyers requested interim measures from the court to make sure the 2 children could be taken out of the facility because their health and well-being was at stake given the conditions prevailing there. And of course, they were intending to apply for international protection and were not allowed to. What is interesting in relation to the plight of unaccompanied children and the position taken from the Strasbourg court is that the ECHR has consistently been known to be very protective when it comes to claims of unaccompanied children detained in inhuman degrading conditions in Greece, and more specifically in ordering measures under Rule 39 of the Rules of Court to transfer children promptly out of the facilities. And we've had recent reminders of that position of the court, not only in judgments delivered last year, such as HA versus Greece and SHT versus Greece and others, which were delivered in 2019 and concerned, among others, detention of unaccompanied children under the so-called protective custody policy of Greece, but also several interim measures in different cases concerning children. In this particular case, the courts refused to grant interim measures, even though it was clear that the children were not allowed to leave the camp, and that the authorities had not made any concrete commitments to transfer them out or to appoint guardians. So this might signal a potential shift in the court's approach to deprivation of liberty, at least where it deems that deference ought to be paid to national governments, given the sort of political sensitivity of the context in which the court was called to assess the circumstances. The second element that has become more prominent, and probably for all the wrong reasons, is compliance with the non-refoulement principle. So of course, as we all know, pushbacks in Greece are not a new, let's say, phenomenon and have been endemic when it comes to areas such as the Evros land border. What has happened since the beginning of this year, and especially since March, is not only a proliferation of violence, loss of life incidents in Evros, but also a reappearance of very worrying tactics, both when it comes to land pushbacks and also to sea pushbacks. So what the government has done, according to various testimonies from a number of different actors, is not only extending the informal and unlawful practice of removing people from the territory, even in cases where they have reached areas well within the mainland. For instance, detention facilities in northern Greece, or even open reception facilities near Thessaloniki, meaning that people are arrested and transported several hundreds of kilometers away from where they have been found, and then a couple of days later are found in Turkey after pushbacks. But also a reappearance of Hellenic Coast Guard tactics of sea pushbacks, especially from the Eastern Aegean Islands. So there's been reports, especially since the end of March, of several groups of people arriving and seen by eyewitnesses on islands such as Chios, Samos, but also Lesbos, where people have also been in touch with organizations and with practitioners. and those people have disappeared a couple of days later and then have been found in Turkey. Of course, that sort of feeds the government's zero arrivals policy and narrative, because these arrivals are never officially registered or recorded anywhere in Greek statistics. What's interesting, again, in terms of the interplay of the ECHR in that regard is, first of all, the ways in which Greece has misconstrued and often misquoted Strasbourg case law, namely when it comes to the March decision and the let's say the pushback policy that has ensued. There have been official policy statements equating the NDNNT versus Spain judgment to what Greece was experiencing, even though, interestingly, this was very, let's say, narrowly circumscribed by the European Court of Human Rights to the specific circumstances of the Spanish-Moroccan border. But nevertheless, it has provided, let's say, the political leverage for Greece to at least appear to rely on a semblance of legality. And a last point that I'd like to bring up before concluding is the let's say, pending judgments from the European Court of Human Rights concerning older practices, which unfortunately become yet again very relevant given the current context. And two judgments that we're still awaiting that might be of interest in this regard are Safi versus Greece on the one hand, concerning the 2014 shipwreck in Pharmakonisi, where people lost their lives inter alia as a result of dangerous pushback tactics from the Coast Guard. And a case communicated last year, which is called Al-Khatib versus Greece, which concerns, again, Coast Guard tactics, including firing of shots and wounding of refugees arriving by boat off of the island of Pserimos, again, in the Eastern Aegean. So we're yet to see, of course, how the court's going to position itself when it comes to these cases, but it becomes very evident that under that particular context, coupled with the COVID-19 pandemic and the zero arrivals illusion, we're likely to see more of those pushbacks happening. I will leave it at that, but happy to discuss in the Q&A session. Thanks very much.
Thank you very much, Minos. So when Violetta started her presentation, she also introduced us the pending case, the SS versus Italy, which is a case that is not being decided on responsibilities of coast guards in Mediterranean. But in a way, Minos's presentation were an interim measure request that was rejected in the context of the COVID, I think intersects in a very strange and a difficult way. So I'm sure there will be more questions about later on about how, in what ways the European Court of Human Rights should respond to these further amplification of ongoing migration, protection of human rights of migrants issues that are not new issues, but they're becoming even deeper. But perhaps, there are some positive developments. So let's see if there are any positive developments to be reported. Our third panelist is Katherine Costello. Katherine is a professor of refugee and migration law at the Refugee Studies Center at the University of Oxford. And actually, I'm very pleased to say it on camera that from the 1st of July, she will join me as the co-director of the Center for Fundamental Rights at Hertie School, and I look forward to that. And she will take up the professorship of fundamental rights here. Katherine is the co-editor with Michelle Foster and Jane McAdam of the forthcoming Oxford Handbook of International Refugee Law in 2021 forthcoming, and also leads the ERC project REFMIC, examining refugee recognition and mobility in the global refugee regime. She also recently co-edited a special issue of the German law journal Rideta Marman on border justice, examining accountability for human rights violations in migration control. Katherine is going to mainly focus on detention practices and how these have intersected with responses to the COVID-19 pandemic in the recent months. Thank you for joining us, Katherine.
Thanks so much, Bashak and Konstantin, and it's really nice to see familiar faces. So I was going to talk about detention, but I did want to step back from the topic a little bit in the sense that obviously immigration detention is a system which depends on prior questions about migration status and which sorts of migrants end up being deemed to be illegal or unwanted in a way that they end up at the sharp end of immigration controls. And I think the way that the pandemic has sort of used immobility for the general population, and so in some ways we've all been immobilized in a way that is something that is more typically associated with, say, the conditions of people who might want to flee to seek asylum and they have no legal options to them. And then in other contexts has made others legal. And so some states have regularized both formally irregular migrants and others. There have been some regularization practices in Italy, for example. I think it just sort of puts into sharp relief the question that practices like immigration detention and then the very sharp and violent end of border controls, which Violetta and Mina spoke about, are sort of all products of systems of immigration control. These aren't natural categories. And so I guess with that as sort of a background, what I wanted to do was actually just go back to some first principles about immigration detention and just sort of recall some points that I had made also with Minas in some earlier work, reflecting on those points, and then look at sort of two new cases and contrast the take of the Strasbourg court and the EU Luxembourg court on some important questions related to immigration detention, and then maybe draw out some conclusions about those in the context of the pandemic. And in some ways, the pandemic should change everything in relation to immigration detention. In particular, when you think that most immigration detention, I mean, in some jurisdictions in particular, is ostensibly sort of pre-deportation detention. And if states aren't able to deport because there just aren't flights, or it's too much of a public health risk to actually deport, or another state won't take deportees back, which happens in some instances, then ideally the sort of grounds for detention should just evaporate. And that's before you get into questions about the health risks. And I think the other point that the sort of pandemic changes is if we think about the line between detention and just containment or requirements to reside in particular places. And obviously that's a legal hot issue that I'm going to allude to also. But if for example, a refugee or an asylum seeker reception center becomes subject to a kind of a lockdown measure, then does it legally become a place of detention? And does that then change the legal responsibilities of the state? And of course, in the background to all of that, or very much in the foreground, I guess, is thinking about the heightened health risks for all populations living in just institutional settings and overcrowded settings, and whether the health risks then are of such a grave magnitude in light of the risk of coronavirus infections that any justification which might have existed for either the requirement to reside in a particular place or the detention itself might just fall away. And I think these are all the sorts of questions that in some countries courts have been examining, and in others there's just been a bit of enlightened practice, and in other contexts I think governments have really just continued in a very sort of repressive and restrictive manner. So just to move through the slides, I was just wanting in the beginning to recall a couple of pieces that I had done when Minas and I a few years ago looked into the EU system. I think one of the things that's interesting about EU law on detention is that it has some rules on immigrant detention that are fairly protective, and in some respects more protective than the standards articulated by the European Court of Human Rights. But, and there's always a but, I think, it also creates a really strong set of reasons to detain asylum seekers, in particular kind of linked in with the Dublin system, whereas any sort of movement of an asylum seeker within Europe becomes something that's framed as absconding, and you get a ground of detention being sort of manufactured out of that. And that sort of echoes points that I had made in some of my earlier work about how immigration law creates these grounds of detention. So it becomes very difficult then to test whether they're really convincing legal grounds of detention. And so that there's a very strange kind of shifting approach to grounds of detention in the law. And unfortunately, and this is in my next slides, when you look at the Strasbourg case law, although it is protective, and I don't want to say it isn't helpful and important, I've always thought it actually kind of sets up a lot of difficulties when assessing my immigrant detention. And I think from my point of view, I guess I've always criticized it as being underprotective. So just for that reason, when I think about immigration detention and its lawfulness, I tend to always just want to remind people that the EChR standards are quite helpful, and they articulate something quite important in terms of just a basic requirement that detention has to be necessary. And here I'm not saying anything new. I think everybody, all scholars who've written about immigration detention in European law, under the ECHR in particular, have pointed out, well, it's very strange to set up a human rights system to scrutinize detention and not require that the detention be necessary for the ground that the state is claiming, because otherwise you're setting up a very loose nexus between the practice in question and the detention itself. And what you get from the ECchR and the Human Rights Committee, I mean, this is just an early case against Australia, there are hundreds along the same fact patterns, is just a very strong statement of principle that you can't have any general grounds of detention. So it goes without saying that the Greek blanket detention, which Minas described, is in breach of human rights norms just on that basis alone. So turning then in the next slide to the Strasbourg case law, and I might be just, in some ways I'm recapping very familiar stuff, but I want to try to work through some of these questions of principle in this new pandemic era. And I think one thing that's important to bear in mind is that the grounds of detention under the text of the ECR are specified to two. And so you have the possibility of detaining somebody to prevent them from effecting an unauthorized entry into the country, or with a view to deporting them. And I think what's important is that if those provisions are to be protective, and if they are to give effect to the presumption of liberty, and if they're to be sort of in keeping with those basic sort of lexical priority of the human right in this context, they have to be sort of understood not only narrowly, but they just have to be clearly contained. And so I think the weakest point of the Strasbourg case law has actually been on detention of asylum seekers in particular, but anybody really of irregular status who comes and then claims asylum or some similar protective status. Because I think in that context, the Human Rights Court should have just said, well, at that point, the person is no longer in a situation where the state can say they're preventing his effectuation of an unauthorized entry. That person has then claimed asylum and is thereby manifesting their faith in the public authority of the state, and is in a legal process which the state is then responsible for running properly. But of course, the Strasbourg court didn't say that in its leading ruling on this in Sadi versus the UK. And I think similarly on pre-deportation detention, the leading case, although it's got very important principles in it, and we can definitely work with them, and we do work with them, and human rights lawyers do use them to great effect. You know, I think that basic instability is present in those two cases. So just I'll skip very quickly over the next couple of slides where I just recap Sadi, I think, and also in the next slide, just remind us that there were very nice dissents in it from very important judges in the Strasbourg court. And of course, the case law has moved, and certainly cases on children, there's now a requirement of necessity, and there's been some tightening up. But I think the basic point still stands that this case law to me actually gives states a lot of grounds to detain. And I think that one of the most powerful critiques is actually Mary Benedict Dembour's comparison with this Inter-American Court, which just has a completely different starting point, which is that it's not okay to have groups of people just almost kind of provisionally in the state with a threat of deportation hanging over them, which is effectively the way the Strasbourg court thinks, I think, about people who have an insecure migration status. So just moving ahead then, on Shahal, I can just very quickly say I think the instability there, or the weakness in the case, is that you don't have a necessity test for the link between deportation and detention. I think what has been important is that Strasbourg and EU law make it very clear that if somebody is an asylum seeker, they can't be in pre-deportation detention because the state can't treat them as if they may be facing deportation when in fact they may be protected against being refoulement and maybe a refugee. So at least for a period of time, there's a legal space where people can't be subject to pre-deportation detention. So obviously these are leading cases, and there's been just a whole range of additional case law and important Rule 39 rulings, which have, resulted in the release of people from detention. But I think in effect, the Strasbourg rules don't really preclude immigration detention, or certainly don't stop states who want to develop very widespread systems of immigration detention. And I guess with that in mind, I think if you see a dilution of the Strasbourg standards, that seems even more worrying. So the final thing that I wanted to do was to sort of compare the two recent rulings, which come, I guess, along the lines, and I guess certainly in terms of the Ilias and Ahmed ruling that I'm going to discuss, you have a sense of a Grand Chamber ruling joining at least a trio of cases where you've got a lot of certainly legal rhetoric in the case that suggests that the Strasbourg court is taking an even more indulgent approach to states' migration control prerogatives. So just moving along then, I was, for many years, I used every single presentation I had a contrast between the Strasbourg and the Luxembourg court. And usually what I was trying to argue was that there were very strong institutional and doctrinal and constitutional reasons why we should expect more from the European Court of Human Rights. And in this particular constellation, I think we've got that, although the cases themselves are so dismal and the practices underlying them are so dismal that it's hardly a cause for celebration. But the cases that I wanted to contrast, to conclude, as I said, are Iliad and Ahmed and an FMS. And in the background are the EU rules on detention, which are tighter than the Strasbourg ones, and clearer in the sense that they have more limited grounds of detention. And in particular, in the next slide, as you'll see, a legal requirement to always consider alternatives to detention, which in effect is a necessity test, and quite a strong one potentially, where states really have to ask themselves, is detention necessary in order to achieve the aims being pursued? So to conclude, I guess on Ilias and Ahmed, I'm sure some people will have had read the case already, and I think Vladislava Stoyanova's analysis on the blog is really spot on. But basically in that case, the Strasbourg court, in the Grand Chamber ruling of the 21st of November 2019, examined the practices of what I think are detention, but that's the question, confinement in the transit zones in Hungary, at the Hungarian border with Serbia. Now, I guess in the background is the fact that the Strasbourg court has also had to give several, quite a shameful number of Rule 39 orders to make sure that people in those centers are not being starved through the official policies of deprivation of food. But in Ilias and Ahmed, the question related to returns to Serbia, and the court was willing to say that there had been a procedural violation of Article 3 ECHR in terms of the returns, because the risks that were posed in the return and the likely treatment that Serbia would mete out to the individuals concerned hadn't been properly assessed. But even in light of that background finding, then deemed that the confinement in an immigration transit zone was not detention. So distinguishing that scenario from its previous and really long-standing ruling in Amourant versus France, where they had looked at a place of transit, but in an airport. And in relation to the airport context, the court had said, well, if you can't leave the airport, then that's detention. And for the government to say, oh, well, you can just hop on another plane and leave, that doesn't obviate the fact that you were actually detained. Whereas in Ilyas and Ahmed, the Strasbourg court seemed to be just really finding a way to distinguish. And it found a way by basically saying, well, you're free to walk out of the center at the Hungarian border and re-enter Serbia. Without actually checking whether that was the case, and without actually taking into account that it had found an Article 3 violation in the way that people were being returned. So I think the criticism of the case is really warranted, and some of the language in the case to me is just really extraordinary, because it's almost an admission that, you know, the court is not only in the business of setting out principled limits on state power, but is also in the business of being practical. And the language of practicality in this area I think, is really striking. And so Ilyas and Ahmed, I think, understandably attracted a huge amount of criticism up there with ND and NT, and with the ruling which we're going to hear about next. So anyway, the slightly happy ending is going to be that the European Court of Human Rights on the 14th of May ruled that confinement in these places is legally detention. And that has all sorts of different consequences legally for how people should be treated. But as I said, and there is a very strong endorsement of a much more functional and protective understanding of detention, because it simply acknowledges that if you're in a place where you can't leave to go anywhere you want, so if there's only one exit route, and that exit route is into another country where you don't know your fate and you may be subject to a range of penalties or ill treatment there, that it just, that potential door elsewhere does not alter the fact that you are actually being detained if you're being confined in a particular place in that way, which I think is a really important point of distinction. But of course, it still doesn't really alter a whole lot of the questions that the pandemic raises. I think what it does helpfully do is clarify that if you're in a place of confinement and your right to leave it is constrained, even if there might be notionally a right to leave, that at some point that materially becomes detention. And of course, that does have very strong implications for the protective obligations and the positive obligations of the state for detainees. I think what's really troubling in the current era is that, obviously, as we know, some states have been receptive to arguments that immigration detention isn't appropriate in the pandemic, both because removal is impossible or simply inappropriate, and obviously the most important reason would be because the public health risks are too high. But as I mentioned, from what I've seen, and mainly I've been just following this through the great work of the Global Detention Project and other NGOs, many states, even states that have taken quite an enlightened approach to prisoner releases, haven't done the same with relation to immigration detainees. And just to conclude a little bit on the UK experience, because I followed it a little bit, the NGO Detention Action has been really playing a really impressive both strategic litigation and advocacy strategy on this. And I was quite shocked when they their first court application to the High Court in London was rejected on what seemed to me quite flimsy grounds, where the High Court sort of said, well, we know the Home Office is reviewing the appropriateness of immigration detention, so we don't think we need to give you any order to the effect that, you know, there needs to be a systematic review of the legality of detention in light of the changed conditions. But nonetheless, several hundred people were released from immigration detention. And in addition, what I thought was really noteworthy is that the detention action had to crowdsource funding for expert reports on the increased health risk to detainees, and found that there was a sort of a likely scenario of about a 60% infection rate if people were confined in the kinds of accommodation that immigration detainees are generally kept in. And you can imagine that if you were talking about the kinds of centres and places of detention in Greece, that might even be higher. So the UK context, it's been it's certainly not a success. It's been one of these typical sort of very hard fought advocacy and legal battles. And in the background too, then other NGOs that normally support immigration detainees have been able to bring bail applications, and the judges at the lower level have been, I think, overwhelmingly releasing people from immigration detention, including in online proceedings. So I think even in a state like the UK, which is still ostensibly claims to have fairly strong protections for the rule of law, you can see that this is really sort of a hard-fought liberty for immigration detainees, even in the pandemic era. Thanks.
Thank you. Thank you very much, Katherine. I introduced you to say, perhaps there are some good news. Well, I think there you ended on some positive note, but of course, the note has to do with the Court of Justice of the European Union calling what it looks like detention, and perhaps some positive examples from the UK of releasing people in the context of the pandemic. Our final panelist is going to take us to perhaps a slightly different dimension to what we have been discussing so far, but I'll explain a bit more in a minute. So let me first introduce our panelists. So our final panelist is Moritz Baumgartel. Moritz is assistant professor at the Faculty of Law, Economics and Governance of Utrecht University, and also at the University College Roosevelt. His book entitled Demanding Rights, Europe's Supranational Courts and the Dilemma of Migrant Vulnerability was published with Cambridge University Press in 2019. Moritz will discuss a particular case that has just been very recently delivered by the Grand Chamber of the European Court of Human Rights, and this is the MN versus Belgium case. This was a much awaited judgment from the European Court of Human Rights, and it concerns humanitarian visas, the question around humanitarian visas, if we may put it that way, but the questions I think are much broader than that as well. Now, obviously this case is not a COVID pandemic related case, but it is the first judgment that the court delivered when it was in social distancing measures itself. So it is the court's first COVID case, if we may put it that way. And of course, the proceedings have been going for some time before the European Court of Human Rights. So floor is yours, Moritz. What is this case? What is your take on the case, and how do you make sense of it in the context of the pandemic?
Yeah, thank you, Başak. And it's really a great pleasure and honestly also honor to join such an esteemed panel. So thank you very much also to Konstantin for inviting me. And yeah, as Başak already mentioned, the case of MN and others versus Belgium is not as such directly related to COVID-19, the crisis, and all the measures that followed. Most of the relevant events in this case actually unfolded between the summer of 2016 and spring 2017. So sometime after the long summer of migration of 2015, but really way before the current crisis started. I give a few remarks about this case also, but I'll not make it too long also in order to be able to give the floor to the questions. So I just situate the case and explain a bit of my thoughts on it. So in this particular case, it was about a Syrian family with 2 minor children who had traveled to the Belgian embassy in Beirut from their home in Aleppo that had been destroyed previously to apply for a short-term visa, and they had relied on Article 25 of the EU Visa Code to basically argue that a short-term visa should be extended to them because there were humanitarian considerations at play, which would basically make those humanitarian visas. And the Belgian, and they were of course planning once they had arrived in Belgium, then to apply for asylum status, which would have refugee status, which would have most probably been granted considering the situation in Syria and Aleppo specifically. The Belgian Aliens Office, which was in charge of looking at this visa claim, rejected it and a quite complicated or protracted appeals procedure followed. The Aliens Appeals Board, which is the higher judicial instance, it's initially sided with the applicants, but eventually the case was closed and determined to be in favor, or was decided in favor of the government for procedural reasons. And in the blog that I wrote or published on Strasbourg Observers, I explain some of the details concerning this dismissal, which is not that important for the purposes here, I think. I think it should be mentioned at this point also for those listeners who are not necessarily familiar with the case law, that the European Court of Justice had confronted a similar case in early 2017, and it was also rejected as falling outside the purview of EU law. And this was so because the applicants, which in this case was also a Syrian family with children, had actually been seeking a stay, obviously because they wanted to apply for refugee status, a stay that is longer than 90 days, which means that their cases were not, according to the court, covered by the EU visa code, and more specifically Article 25. And the European Court of Human Rights, of course, not concerned, or doesn't concern itself with the visa code, but rather with the convention. So here the question then arose, so that's the MNN case again, whether denying the humanitarian visa constituted an infringement of Article 3, because basically the family was not accorded protection. So the Grand Chamber of the European Court of Human Rights denied that Belgium had any jurisdiction according to Article 1. And it declared the application inadmissible, and that was in early May. And as already said, I published a blog on Strasbourg Observers shortly after this judgment. I'll use this occasion here to sum up some of the observations that I've made there and add maybe a few thoughts on it. First, I think it's important to point out that this legal outcome really cannot be divorced from the political context of the case. And I really do maintain that this is the key to understanding the case, the ruling, because and this is quite a bit different from the argument that has been made, or that one hears more recently, that the court has become more restrictive, which may well be true, but that implies in a way that it may have decided differently on such a case in previous years. And I would really disagree with this standpoint, because ultimately this case concerned admission, or as I refer to it in the blog, legal pathways for potential asylum seekers to enter European states. And the Strasbourg court really has always skirted this issue, because it really constitutes a hot potato, politically speaking, even in normal times. And I think this sentiment would have actually been even stronger in the present context related to the COVID crisis, where states have, and we've heard a lot of very pertinent points and good examples about this, where states have routinely restricted travel without actually that much opposition in many cases from the human rights community. So I think this is a really overall and potentially really important takeaway from a strategic point of view, because it suggests that the court will probably be more useful to help vulnerable migrants who already find themselves on the territory, or at least within the purview or on the borders of the territory of a Council of Europe state party, as for example is the case when it comes to the terrible, well, quote unquote reception conditions in Greece, as we have heard from Minos, or also in cases related to detention, as explained by Katherine. The second point that deserves attention is the legal question of extraterritorial jurisdiction. Now with Violetta here, we have got probably the foremost expert on this topic in our webinar, so she may or will probably chip in as well afterwards. In my view, we do not actually learn that much from this particular ruling, because the jurisdictional claim of the applicants was rather thin. And I do in the blog also distinguish it therefore from, for instance, or most notably, S and others versus Italy, so the case regarding the pullbacks and Italy's involvement for these Libyan pullbacks in the Mediterranean. So why was the jurisdictional claim thin? Well, for one, the applicants had entered and left the embassy out of their own volition. I think it's an important point that is just that makes a lot of sense. If there's one aspect to this particular case which would suggest that it could have gone in favor of the applicants, then that's perhaps that the Belgian Aliens Appeals Board had actually found there to be a violation of Article 3 at some point in the domestic proceedings, which means that it had basically established its own jurisdiction. I still think it would have been surprising given all the political aspects that I mentioned before, but still not entirely shocking for the European Court of Human Rights to hold this to be enough for there to be jurisdiction. But even if that had happened, I think it would have been a one-time win, really not something that would have had a systemic impact. Because basically things such as discretionary humanitarian visa provisions could have been removed by states as a reaction to this judgment, or they could have outsourced pre-vetting procedures to third parties and so on. So maybe in short, it's just really, it would in that case have been more of a sui generis case at best because of the particular procedural trajectory that it had taken. And I seriously doubt that it would have effectively reaffirmed the extraterritorial jurisdiction of state parties, which could have really easily taken measures to remove that jurisdiction. Again, and this is a dynamic that Itamar Mann once referred to as the dialectic of transnationalism, and it's obviously also at play in other cases, such as the case of SS on the pullbacks in the Mediterranean. Which has basically replaced the pushbacks from 10 years ago. So really, by means of conclusion, I think that MN is a judgment that is as firmly based as it could be on the status quo, at least the pre-corona one. We know that the absence of legal pathways is what makes people risk their lives crossing borders to Europe, often in reliance of human smugglers and very much despite what Violetta called death-based containment efforts. But we also know that the European Court of Human Rights has not delivered one single judgment in all these years and decades that would mitigate this tragic situation in any proper way. And if any of this is to change post-corona, then it's more likely to be because of political change rather than some decisive ruling by the court. And this, I think, has become exceedingly clear by now. Now, don't get me wrong, I don't think that political change is likely. I think we have heard many examples of things actually going in the opposite direction. We will probably have to deal with an economic crisis, which often is blamed on migrants who are then scapegoated and targeted under the pretense that the national economy has to be protected. We shouldn't be surprised about any of these political moves. However, perhaps the crisis does weaken right-wing parties in the medium and longer term, bring about a new politics of solidarity. This is a very hopeful, obviously, note. But I think we do have seen perceptions of what can be achieved politically changed. The odds are obviously not very good, but I think it's certainly preferable to focus on this rather than hoping that the Strasbourg court will deliver some sort of magic solution on questions of legal pathways at the very least. Thanks.
Thank you. Thank you very much, Moritz. My biggest takeaway point so far has been that the COVID-19 has definitely made the human rights of migrants worse. Even though there are some positive examples on balance. This is kind of what I've been hearing. And a very interesting question about whether the judicial institutions, in particular the human rights courts and the Court of Justice, will be able to be responsive these sort of worsening scenarios. And I think we've heard some very different answers to that so far. So I thank the panelists very much. This is the time for the Q&A session, and I'd like to hand over to my co-chair, Constantin, at this stage to moderate the Q&A session that is to follow now.
Thank you very much. Thanks, Bashak. I think we had a fantastic set of presentations, and thank you very much to all the panelists. I myself learned a lot from what was said. Now, I haven't seen any questions on chat. Can anyone raise their hands or let me know anyhow if they want to ask any questions? While people are thinking, I don't know, maybe I have a question. Forgive my ignorance. Do you think that formal declaration of Article 15 emergency, something that we discussed in the very first webinar quite a few weeks ago, would have any impact on the scope of rights of migrants? Is there would Article 15 derogation mean anything for the rights of migrants? That is my question. Maybe somebody else wants to ask anything. Don't be shy. Okay, if there are no questions at the moment, maybe we can kick off by starting answering that question first. Katherine?
Yeah, well, I don't know if I'm on, am I?
No, yeah, I can hear you. Yeah.
Great. I mean, you've asked a question that I have on my list of things to read about. The debate, I thought, was very interestingly framed, because there were, obviously there has been quite a lively debate about this. And I mean, some of the proponents of invoking Article 15 see it as a more sort of ultimately more human rights protective, because you would have to kind of explain and constrain, or the state would, what the scope of the emergency is. I suppose when I think about migrant rights, I think migrants already sort of fall into an exceptional category. So my knee jerk is to think, do you want emergency powers on top of that? And also, do you want to set a precedent where, because from a state's point of view, Europe has a perennial migration crisis, because it, for this relatively small group of people who might kind of completely lack legal routes to travel to the EU, every time any number of them arrive, that looks like a crisis of some sort. It's some breach of the legal order. And so I think that there's such a knee-jerk reaction to frame everything as a migration crisis. And you also have that language sort of also very prevalent at the international level. And so I guess my sort of not very well considered answer is that I would just fear in what sorts of contexts then states could use that again against migrants to sort of dilute rights protection that's already pretty weak anyway. So what additional powers would states need to claim over migrants? And I suppose the only upside I could imagine is that if the COVID emergency had to be really clearly framed in public health terms, then of course, and if that somehow meant that states had to justify their actions solely in public health terms, then you might be much better off, because obviously then you would just have to really look at the health impacts of these practices, whether it's deportation or detention or containment in overcrowded centers. And then you're clearly not going to find a public health rationale for the types of practices that are kind of baked into European migration control. But I just don't know if I don't think that's really what declaring a state of emergency and using Article 15 derogation powers actually gives. Although I would like if it did. So.
Does anybody else want to chip in into this question? Or Violetta, yes, please.
Yeah, no, I share Catherine's misgivings, but I think the upside, if states would have gone through the effort of you know, activating Article 15 and having to, for example, you know, provide the justification for the measures that they are adopting, I think that would put them, that would have shown the true colors of the measures that they are adopting and put them under pressure to try to justify them, right? Because under Article 15, they can only adopt the strictly necessary measures and those which are not inconsistent with their other obligations under international law. And discrimination on grounds of nationality might be something that states can do under international law, but I don't think it is justifiable to the extent that we see it being practiced after COVID. So if you take, for example, the port closures example that I was talking about during my presentation, under the law of the sea, you can close ports for emergencies, but you cannot be selective as for whom the port is closed to. So you can close your port if you declare it unsafe, but then it's unsafe for every foreign flagged vessel, not only for those carrying both migrants, right? So I think it would have been interesting to see how states would have tried to articulate the basis on which the measures have been adopted. And several of them have anyway gone and declared public emergencies, if you think about France or if you think about Spain. The non-declaration of an Article 15 process, the risk of not having done that is that you normalize exceptionalism. So the exceptionalism that Katherine has mentioned goes unheeded and unappreciated because it's normalized by the nature of not having invoked the Article 15 exception. And I think that constitutes a risk. Then from the procedural perspective, Article 15 declarations are not eternal. They have to be declared for a period of time through which, in theory, the Council of Europe monitors what states are doing and whether they comply with their other obligations under international law. So I think procedurally there have been a mechanism to check that states were doing what they had to do under international law, and compliance with the principle of non-discrimination and proportionality would have been an interesting thing to see. So on balance, I think I would personally have preferred that they tried to justify these measures under Article 15, because it would have been well nigh impossible to make justifications in line with international law.
Thank you very much. Moritz, do you want to? You are muted. You need to unmute yourself.
Yeah, I also I wholeheartedly agree. I just maybe to add, I think it's just the basic starting point. I think should always be to assume that in principle states do have a lot of leeway to act and protect their borders according to the court. So the status quo is already extremely favorable, which is why then declaring Article 15 would make it, would perhaps narrow this. I completely agree with Violetta. So I think this is important to keep in mind in this context.
Well, it seems that I'm very much in minority about Article 15. I just finished writing the paper, so arguing that it's not really necessary in the situation of pandemic. But it doesn't really matter. We have 3 more questions. I think one question
one more thing, Constantine,
yeah,
if I may. So when you declare a public health emergency and then you try to justify the measures that you are adopting vis-a-vis migrants on the grounds of a public health emergency, indirectly what you're saying is that the health risk is carried by the migrants. And that would absolutely require justification, because otherwise, how else are you justifying the measures that you're adopting? Because I don't think you can declare the whole country to be unsafe for migrants and then try to sell the measure as a liberal one that concerns the preservation of the health of non-citizens, particularly if those non-citizens are trying to escape war or persecution, situations where they are drowning at sea or where they are languishing in some transit countries that doesn't provide any protection at all. So I think the effort to justify and to demonstrate that the measure has, if not a cause and effect link, at least a logical connection with the claimed benefits of the adoption of the measure. I think that would have been really interesting. Sorry, go ahead.
If I may also just really, because I completely, I mean, if we look at Marie-Bénédicte and Boer's argument on the human rights reversal, the point that the point of departure is that states have a sovereign right to control their borders. And basically what it does, it removes any proportionality analysis, because you start there and then look at the exception that perhaps is there in human rights terms, rather than the other way around, where you look at the individual rights and then look whether any limitation is proportionate and necessary. So, and this is precisely this point that indeed you would have to justify it, and also in terms of whether this is really the way of going about things, which states would not want to do. Yeah.
All right. Very interesting. I see that my position is not very popular among the panelists, but I just think that Article 15 just incapable of doing what you hope it to achieve, and not that I wanted to achieve, not that I don't want it to achieve. Anyways, we have 3 other questions. Maria Julia, can...
Hello. Hi.
Hello.
Hi, Constantine. Thank you very much, you all, for your brilliant presentations. Really, thank you so much. I just have a question for Violeta, and I wish to bring attention to some of the most recent cases of rescue interception at sea. As you know, recently Malta has tactically disengaged from rescuing migrants, letting Libyans intervene within the Maltese SAR area, where the distress took place, and pull migrants back to Libya. And in some of these cases, Italy has opted for a more, let's say, timid or end-off approach, seemingly more marginal from an operative standpoint, as people were rescued in a SAR area under the Maltese jurisdiction and with the involvement of Libyans. However, I think the role of Italy cannot be neglected, and indeed in these recent cases, the Italian Rescue Coordination Center has received distress calls, and Italy has also been often been the country closest to the place of distress. So my question is whether you think Italy's jurisdiction and therefore potential responsibility can still be engaged in these circumstances in which, let's say, Italy doesn't have a primary responsibility to coordinate the succors, to rescue and disembark the people in a place of safety. And in this particular case, in which Italy is not directly involved in the coordination of the rescue, as is in the SS case, can we still enter the realms of Italy's complicity for its comprehensive involvement and support to Libya over the last decades in the planning and enforcement of pushbacks by proxy policies? Thank you very much.
Violeta, do you want to answer to this question? And then we'll have 3 more questions and close.
Sure. Thank you, Julia, for the question. Although I think, I mean, you already know the answer. At least you know what my answer is going to be. So, I mean, to me, what triggers the obligation in terms of the positive duty to preserve human life at sea, it's the receipts of the distress call, and that's sort of black and white on the SAR and SOLAS conventions. And that is independent of where, in terms of location at sea, the situation sparks. What the determination of the SRR does, so if the location where the situation sparks is the search and rescue area of Italy, that then adds on an extra duty to cooperate with other maritime assets and other coastal states to arrange for the conclusion of the rescue efforts and the disembarkation in a place of safety of the migrants that might have been retrieved. But what triggers the obligation to assist, it's actually the core of distress, or the knowledge, actually, the knowledge of a situation of distress through whatever means, whether that is a satellite phone call or imagery that comes from radar detection or satellite images. So the medium is not really important. The location, it's not really important. What triggers the obligation to assist is the knowledge that people are in distress and in need of assistance. And I understand that this can have far-reaching consequences, but then what this facilitates is that the discussion is held in terms of factual factors. So when exactly was it that you can say Italy was aware of the circumstances? And that's the point at which I think responsibility is activated. And I think that would be a primary form of responsibility, not really engaging the complicity framework. And why I'm saying this, because in the SS scenario, for example, and I think the same has happened in the COVID, in the post-COVID situation as well, what you see is Italy actively evading any form of contact being established with the migrants through early detection of their situation before you could say that they are in immediate need of assistance, through radar and satellite detection, and then calling on the Libyans to intercept the vessels before anyone has declared a situation of distress. So I think the ultimate cause of the line of effects we see materializing at sea is the knowledge by Libya that this is happening at sea. And that's, I think, the point at which responsibility should be understood to have been engaged.
Thank you very much, Violeta. We have two questions from chat, which I will briefly summarize for the benefits of our participants watching us on YouTube. One question was about accountability of states that are externalizing their border controls on infected irregular migrants. And the second question was from Ed Bates, who wondered about the fact that the Human Rights Committee and the UN Special Rapporteurs have stronger or higher standards of protection, and how that can be explained. And the last question, we will take three questions in a group, if you don't mind. The last question, I think Arndis wanted to ask, and I will give her a floor right now. So Arndis, if you want to ask the question, please unmute yourself.
Yes, can you hear me?
Yes, yes.
Okay, thank you. I have a question I would like to pose to the panelists. I would be interested in knowing their perspective. I don't know if it's a little bit off topic from what people have been asking about until now, but I'm curious about the comparison of government's reactions to detention. Now they seem to be justifying detention of migrants with reference to this emergency situation, etc. Whereas you have in general cases as regards general law enforcement, etc., and imprisonment of people, they're actually doing the opposite. They're justifying the non-detention of people that would otherwise be detained with reference to the situation. So my question, maybe it's not very very thoroughly formalized, but if the panelists have any thoughts regarding this, I would be very interested to hear that. And thank you, thanks everyone for all your thoughts. It's been very interesting.
Thank you very much. Does anybody have any comments to share on that? Violeta and Katherine. Okay. Violeta, can you unmute yourself?
I was going to let Katherine take probably the two questions on detention and the higher standards by the Human Rights Committee. But I mean, since I have the floor, I'll just say, in terms of the higher standards from the Human Rights Committee and the UN rapporteurs, I mean, I think because they are supposed to be not real courts, or at least they are perceived by states as not delivering hard law decisions, maybe they see themselves as with the capacity of pronouncements that are a bit more generous, or at least more in line with the ideal and the spirit of the provisions enshrined in international human rights law instruments. Although, I mean, to me, the fact that the European Court of Human Rights has been faltering for a long time when it comes to the human rights protection of migrants, that's what is most worrisome. I mean, to me, we shouldn't be perceiving the Human Rights Committee and the UN rapporteurs as being generous. To me, they're doing what they should be doing, not taking any color from the fact that the migrants are migrants, and they're doing sort of their job in a way that it's more in line with the universalism predicated of human rights protection. So to me, it's not really a problem of the Human Rights Committee and the UN rapporteurs being more generous. The problem lies with the fact that the European Court of Human Rights has been really not fulfilling its job as it should when it comes to the human rights of migrants for a very long time now. I think the latest decision, which you could see them doing their job, was hearsay, and that has been followed by a backlash, which is now lasting more than 10 years. And in terms of government reactions to jurisdiction, to detention, sorry, what I think, and these tallies also with a comment that Moritz had made before, I've seen governments justifying some of the treatment that they lend to migrants in the COVID framework as being for their own good, right? And taking consideration of very paternalistic assumptions as for, taking those assumptions to justify, which are very reactionary forms of migration governance. And so detention for their own good would be one of those kind of discourses that I think have been mobilized. Closing ports because they are unsafe for them, that's another way of very much twisting the terms of the debate to justify measures which are just not in alignment with human rights. And then what you see in MN and ND and NT and this line of cases, when they say, well, they entered the embassy premises of their own volition, or well, they approached the Melilla fence of their own volition and they stormed the fence because they wanted to, just ignores really like the broader picture of migration and forced migration in particular, as if forced migrants had options, and as if those options were such as to modify the nature of the human rights law obligations of states. So I think COVID has been very insidious in serving states to articulate discourses that are really against a plain and non-sympathetic reading of the very text of the instruments at hand.
Thank you, Violeta. Katherine, did you want to comment? If you could unmute yourself.
Oh yeah, thanks. You can hear me now. Yeah, they were a great question. So the committees, I think Basak has just shared, because Basak and I with Stuart Cunningham did some work looking at the committees on non-refoulement, because it's such a huge part of their caseload at the moment. And the intuition that Violeta mentioned, like imagining that because they're not binding, they have sort of more leeway because states pay less attention to them and there's less political constraints on them. I mean, it's sort of hard to measure, but I'm not sure it's entirely correct, because in some contexts they can be, just as legalistic, and I wouldn't say restrictive, but I mean, I guess just as mindful of state prerogatives. And in others, they are clearly more protective than the Strasbourg court. I think the difficulty is often that the reasoning in the sort of decisions on individual complaints can be a bit Spartan. So you have to try to really figure out what's happening. But I think increasingly it's just a really important source of jurisprudence, and we haven't really fully looked into the question of compliance, but it does seem states, at least the ones that we looked at, did seem to be fairly compliant, and other scholars who are starting to look into compliance are having similar findings. So I think there is a really interesting process going on. And I think in terms of Strasbourg, I mean, we can all sort of speculate, and obviously some people are doing very rigorous empirical study about backlash and political constraints on the court. But I recall once Marie-Bénédicte Dembourg telling me that her engagements with the judges have always been really constructive, you know, because if they want to do a better job, then they need doctrinal support for that, you know, not just critiques that they should be doing things better or in a more protective way. And I think if you want to lend doctrinal support to more migrant protective arguments, I think both looking at the inter-American system and the committees can be quite helpful. The point about detention and versus criminal incarceration, I think that Arna's made us really, I think it's really telling. And I think then it starts to look disingenuous, right? Because even if you felt like certain migrant populations, if people are traveling from countries which have higher infection rates, so take the UK at the moment with its higher infection rate. So is there a reason then to constrain travel, in particular from the UK, because people coming from here going to other places in Europe that have handled the pandemic better are bringing a higher risk of infection with them? Then I would think, well, maybe, depends on the empirics, but it's not implausible. But it would just be a reason to ask them to quarantine for 2 weeks. It certainly isn't a reason to detain people altogether and seed a whole lot of cases that will ultimately have to go somewhere, you know, so either to your local hospitals, or, you know, if you're completely despotic and terrible, you might just let an epidemic run within a detention estate. That seems pretty brutal. But I do think where that is happening, then I think that can really be highlighted just to demonstrate that the practices don't have any public health related justification. And hopefully that might help in this kind of process that's ongoing. And there is a process ongoing in most states with the actors who usually work on immigration detention, I think, working flat out to sort of get releases and change the approach to immigration detention.
Thank you very much, Catherine. I think Minas wanted to make a comment. Please, the floor is yours, Minas.
Thanks very much. Maybe just to follow on from Violetta and Catherine on the point relating to the stance of the European Court of Human Rights compared to UN treaty bodies, and also, as Catherine mentioned, contrasted with the CJEU. I think the political dimension and the reasons behind it are definitely crucial, but there might also be a more practical element which we shouldn't discard, which might relate to fatigue and to overloading the court. And I think this can also very often drive different, let's say, stances or shifts in the court's approach to different cases. Catherine mentioned very instructively the example of Hungary, where the number of Rule 39 requests for something as basic as giving people food in the transit zone has been necessary to safeguard fundamental rights, and where the court has basically been receiving similar types of applications over a 2-year period for something that should have been cleared out since the first Rule 39 interim measures were delivered. Greece is very much a similar example, and there the breadth, let's say, in the spectrum of cases where Rule 39 has moved from something exceptional and urgent to really an individual necessity in every single asylum case is quite striking. We have, of course, detention cases, including those concerning unaccompanied children that I mentioned, where to get a child out of a police station, you need a Rule 39. This is now also an issue that becomes even more prominent in the context of reception conditions, even where detention is not necessarily the problem, where to get people out of places like Moria, Vathion Samos, Kos, Chios, etc., people have to resort to the European Court of Human Rights. And there, inevitably, we ask the court to play the role of a policymaker and a legislator. And that, to me, can never work. I think Moritz also put it very well, that those solutions are not individual solutions, especially if even compliance with those individual measures becomes very, very testing in practice. To give you an example, we've had cases as recent as April 2020, where in the midst of the COVID-19 pandemic, the court has ordered interim measures to get people out of Moria, and it has taken the Greek government over a month to comply, even to transfer a single applicant out of a reception facility to a different one. So if compliance becomes very difficult, both at the individual and at the system level, and of course the backlash never really stops. I think there's no shortage of state reactions to cases where the court sort of forces their hand a little bit. I think it is relatively inevitable that the court will try to let's say, adapt its approach to something a little bit more restricted, in the hope of being seen as more pragmatic. And I think this was also touched upon in the conversation, but vulnerability really becomes the factor there. And it might be interesting to see if there is any extent to which legal practitioners, civil society, academics, and advocates have also maybe unwittingly contributed to that. Because vulnerability is something that in individual casework, because a particular applicant has those very pressing needs, but it might have also shifted the debate a little bit from overall access to protection, access to justice, compliance with safeguards, to really priority being given to vulnerable people, when you might have entire asylum systems that are not Article 3 compliant. So of course the court, to me, can never really offer solutions in that regard.
Thank you very much, Minos. Moritz, do you have anything to add? No? All right, then I'm mindful of time. We are not surprisingly taking into account the breadth of the topic, 20 minutes behind the schedule. So on that particular note, I would like to thank all the participants. I would very much like to thank Bashak for basically organizing the whole thing. And basically, we are taking a summer break from these webinars, and we will continue in September with a new and with other interesting topics. So please stay with us, and thank you very much for all the participants and the panelists and Bashak, and have a great summer, and see you in September. Thank you very much. Bye-bye. Thank you.